The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
All right, we're here this morning to hear motion for reconsideration of bond that's been filed by defense. Defense, you ready to move forward with your motion?
We're ready, Your Honor.
All right, State, are you ready as well?
State's ready, Judge.
Before we get started, defense and state approached me in chambers with a stack of letters. I have read each of these, and I want to say I greatly appreciate y'all getting them to me ahead of time. I know some of these are from I think I have two separate grandfathers that wrote a letter, grandmother, several family friends that were in here, some that had been lifelong friends. There were also a couple of letters from people that just met Miss Patrick after the incident. There was one that was very kind, even said, Judge, I don't envy you and the decision you have to make and the weight of that. So that person, I appreciate that as well. I say that just to let you know I did read these. And I picked out one in particular that said that so that y'all know I did read these. And they do matter. No matter what the decision is that I make today, these letters do matter and they have been read and considered. Okay? All right, State, you ready as well?
State's ready, Judge.
All right, defense, it's your motion.
Thank you, Judge. We are here just for the record on a motion to reconsider bond. We had originally been denied bond back in August of last year, 2025. And since that time, Ms. Patrick has been in custody. I made the court aware at that bond hearing that she was at that time in solitary confinement and still remains in that posture in the Carroll County Jail. So I wanted that to be at the forefront of the court's mind. And with that, Your Honor, we will call witnesses in addition to those letters if the court will so allow.
My understanding is you have two witnesses?
That's correct, Your Honor.
All right, call your first witness.
Dennis Nolan, Sr.
Yes, sir. You'll come around and then remain standing while I swear you in. You'll remain standing and raise your right hand. You swear affirm the statements you make before the court today to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You may be seated. If you would, just once you're seated, pull that microphone a little closer and speak loudly and clearly into the microphone. And if you'll start off by just stating your name.
My name is Dennis Nolan, Sr.
Dustin, you gonna be good? Yes, sir. Okay. Thank you.
Good morning, Mr. Nolan. I believe the microphone just went off. So.
When you pulled it, make it a little You're just gonna have to speak loudly and clearly for us. Okay, so my clerk just said that parent was the other day that had this issue with another court and IT had to come. So just speak up and speak loud for us, okay?
All right, Mr. Nolan, how are you related to Sarah Grace Patrick?
She's my granddaughter.
And are you her maternal or paternal grandfather? Maternal?
Yes.
And so Kristen was your daughter?
Kristen is my daughter.
Okay. Now, Mr. Nolan, have you received, I'll just get to the issue at hand. Do you believe that Sarah is a danger to you or anybody else in this community?
Not at all. No.
Okay. Do you believe that she is a threat to intimidate any witnesses that may be a part of this case?
No, absolutely.
Have you ever witnessed her threaten anybody or do any harm to somebody that you know of?
No, not at all.
Okay. Do you know if she has a driver's license?
She does not.
Does she have a learner's permit?
Not that I know of.
Okay. Does she have a passport?
No.
Okay. Are you aware of how she became arrested in this case?
Yes, pretty much.
Okay. did she turn herself in, or did the police have to go get her?
She turned herself in.
And was that with you or with her father?
Her father.
And is her father, let me ask you this. Were you ever living, or was Sarah ever living with you?
No.
Do you know of Sarah to have any access to any money that would allow her to leave this jurisdiction?
No. Nothing at all.
If she is released on bond, would you be a part of the village to make sure she gets back here to court?
Oh, yes, absolutely.
Okay. And where is it that you live, Mr. Nolan?
I live in Rome, Georgia.
About how far away is that from here?
About an hour and 15 minutes.
Have you received any money from any publications or bloggers or anything like that in relation to this case?
No, nothing at all.
Do you know if Sarah has received any money from any of those sources?
No, not at all.
Do you know if Sarah has any money stored up in some savings account to be able to flee the jurisdiction?
No, nothing.
Now, how old is Sarah?
She's now 17.
Did you write a letter to the judge in reference to this case, or to the bond in this case?
Yes.
Okay. And the judge has indicated that he's read that, so I'm not going to have you read it today, but it is a part of what the judge has been turned over. Okay. Do you know if Sarah has ever been arrested before?
No.
No, she has not, or no, you don't know?
Not.
Okay. Right, that's all I have at this moment.
And I have read your letter, I appreciate it.
Good morning, Mr. Nolan. How are you?
Good, thank you.
Good. Now, you and I have spoken before, is that right?
That's correct.
A number of times, 8 times, 6 times,
Yeah.
something like that? Okay. Almost always in our office, is that fair to say?
Yes.
Okay. You've been invited to our office multiple times. You do live in Rome, so you can't always come down. Is that fair
Right.
to say?
That's
Okay.
correct.
So our office has been open to you
Mm-hmm.
throughout this process.
Right.
Okay.
That's correct.
I do want to talk to you a little bit about what you just spoke with opposing counsel on. You said you never lived with the defendant before. Would she be staying with you now in Rome?
No, I don't, no.
If the only way the judge granted bond was for her to stay with you in Rome, would you open your home to her in Rome?
Probably.
Probably. Where would she be staying? Where would she be staying?
With her best friend, who's, mother's Carrie, I don't know if she's here.
So the defendant would be staying with her own best friend?
Yes,
Okay, and who is that?
Carrie, I'm not sure of her last name.
Okay, Carrie.
She's here, yeah.
Okay, now, does Carrie live in the state of Georgia?
No, she's just over the border in Alabama.
I believe we heard from her at the last bond hearing. So she would not be staying in state, is your understanding?
No, it's just, I mean, she lives right at the border.
Sure, understood.
It's what I feel the best for.
Okay, now, you asked a question a minute ago about whether you had sold anything. You were at one point negotiating with media companies regarding the story, is that fair to say?
That's correct. yes.
Okay, what companies were you negotiating with?
Oh, it was probably 10 or 15 of them.
Okay.
I still have listed.
Sure. Did you sign a contract with any of them?
Yes,
Okay. Which media company did you sign a contract with?
Lady Well,
Can you spell that for me?
it's LADYWELL.
Okay. There you go. Okay. How long is that contract for?
Well, it's for production that will be post-trial.
Okay.
No.
Okay. And what was the compensation in that contract?
I don't recall, I didn't receive anything for signing the contract.
Okay.
There's monies to be paid after the production is made, which would be after the trial, after the production.
So it's all on the back end. Okay. What's that amount?
Well, it depends.
Objection relevant?
Yeah.
Judge, this goes directly to the family's ability to enable her to leave the jurisdiction. This is something that was talked about at the last hearing, where the family had assets. The court determined she was a flight risk because of those assets. Those assets have now increased by, I'm going to guess, between, I'm not going to put a figure on it, I'll let Mr. Nolan put a figure on it, but if the assets of the family have increased and that was a concern for the court last time, it remains a concern for the court this time.
I believe, Your Honor, the testimony is that it may become an asset in the future, not that it's a current asset. And so it not being a current asset, I believe, blocks the relevance of the importance of the dollar amount at this point.
Judge, there's a significant difference between them selling the rights for $1,000 and some of them selling the rights for $1 million.
Let me ask attorneys to approach. Is this a microphone for your camera?
Yes, sir.
Can you cut that for just a minute?
Yes, sir.
Can you cut that back on?
Thank you, sir.
And Judge, if I may, just in addition to the reason that I stated prior on the record, I think this goes directly to the veracity of the statements of this witness, Judge. I think we heard statements just moments ago from him that directly contradict what we're talking about here today. I think this is a relevant area to go into at this point.
I'm going to allow for questions at this time. That was just so the bench conference. That was my concern. I was making sure that that's where we should be potentially with this argument. So I'm going to allow for questions.
Okay, so I'm going to go back. What is that dollar amount?
What is the total amount?
Correct.
I'll be honest with you, I don't recall because it happened months ago. But I believe it was somewhere around $100,000.
And is that 100,000 that will go to you? Who will that go to?
Go to whoever the production company feels contributed to the production.
Okay, so that money will be parsed out depending on who participates in what area.
Right. Yeah, it's all post-trial.
Sure. And who are the parties to that contract? There's Ladywell who's on one side.
Right.
Who is on your side?
Myself, Luann, DJ, and I believe that's it.
And by Luann, you mean Luann Bruce, the maternal grandmother,
Yeah.
and you mean DJ, the biological father of the defendant. Did they pay any upfront money to you?
No.
No penny at this point. Not a cent has come your way.
No.
It is all on the back end.
Correct.
Okay. I want to be clear. Get your testimony here today that none of that money will be going to Sarah Grace. It will be going to Luann and DJ. Is that your testimony today?
That's what I understand, yes.
Will you?
That's my understanding of what's in the document.
Okay. It will not go to Sarah Grace Patrick, is what you're saying. Okay. Understood. Nothing else at this point, Judge.
Anything else?
No, Your Honor, after this.
You can step down. Thank you. Call your next witness.
Luann Bruce.
You can come this way. No worries. So you remain standing, raise your right hand. You swear affirm the statements you make before the court today, the truth, the whole truth, and nothing but the truth, so help you God. If you see, I apologize for I might be out. You'll speak loudly and clearly for me, just to help everyone out. I greatly appreciate it. Just imagine that you're talking through a door, okay? All right, you'll state your name for the record.
Luann Bruce.
All right, Miss Bruce, how do you know Miss Patrick?
She's my granddaughter.
She's your granddaughter. Is she your maternal or paternal granddaughter? Maternal. So you are Kristen's mother.
Yes, I am.
Okay. And has Sarah ever lived with you?
I mean, she stayed with me off and on,
But visitation as a grandmother, that kind of
Of
thing.
course.
Okay.
5 minutes.
Let's address this money issue. Have you received any money from any production company, bloggers, whatever, in relation to this case?
Not today.
Not today. Okay. Has there been any promise of money to you in the future for the rights to this and that type of thing?
After the trial, yes.
Okay. After the trial. But at this moment, you have not received any money as it relates to this case. Okay. Do you know if Sarah has received any money as it relates to this case?
Not that I know of.
Have you given her any money from a production company that you received?
Oh, no.
Okay. Do you know if Sarah has a driver's license?
No, she
Does she have a learner's permit?
No.
Do you know if she's learned how to drive a car?
I don't think so. They didn't have one that she could drive.
Okay. Does she have a passport?
No.
Are you aware if she turned herself in or was she arrested?
She was forced to turn herself in.
Okay. And when she turned herself in, do you know where she came from?
I think she was at our grandparents.
Okay. And that would have been the same house that's in Alabama. Okay. And where do you live, Luann? Like what city?
I live in there now.
Do you have at this point custody of Jaylee? Okay. And that is Sarah's little sister. Okay. Are you afraid for the safety of Jaylee as it relates to Sarah?
Not in the least.
Okay. Is there any, has Sarah ever made any threats to you or to Jaylee at any point in time, but especially in relation to this case?
No.
Okay. Has she tried to talk to Jaylee or change her testimony or anything like that that you're aware of?
I talk to Sarah every day, and Jaylee talks to her when she's here. They're just loving sisters talking to each other.
Have you any reason to believe that she would flee the jurisdiction and not come back to court?
Not at all.
Wait.
She's supposed to fight for her.
Okay. Would you be a part of the community and village that would be responsible for making sure she shows up for court dates in the future?
Do that.
Okay. Are you aware if she's ever been arrested before?
No, she hasn't.
Okay. And you wrote a letter in relation to this case and this bond this morning? Okay.
I didn't think I was going to be able to be here.
Okay, right. You had another work
I
obligation.
had a leadership meeting and I couldn't get out of it.
Okay.
Change that.
The ice changed that. I think it changed a lot of things for a lot of people. But that letter is a part of what the judge has reviewed, and so I wanted you to know that that is a part of it. Now, you are one of the there's victims in this case, right? Would you consider yourself one of the?
I'm very much a victim.
Okay. And as I'm sorry,
My whole family,
your whole family, and you are in support of Sarah
very much so.
and her being out on bond.
100%.
Don't think I have any other questions.
Thank you. Sadie?
Thank you, Judge. Good morning, Ms. Bruce. How are you?
I'm good, how are you?
I'm doing well. Again, same kind of starting questions. You and I have had conversations in the past. Is that right? Okay. I do want to ask you just a little bit about those media rights that we've been talking about. How familiar are you with those media rights?
I mean, vaguely familiar, and I've talked to them, and, you know, it's all based on what will happen after the trial.
Sure.
Who they're gonna, you know, make go through all the, going with pictures and stories and all that kind of stuff.
Okay. And the three people who are involved in that are you, Dennis, and DJ. Is that correct?
Correct.
So the $100,000 or so that we've been talking about, that will get sort of divvied up between that group. Is that right? It won't go to Sarah Grace. It won't go to her sister Jaylee.
Yeah.
It won't go to anybody else. That's money that's going to go directly to your pocket if you were participating.
Yeah.
Okay. Now you don't live near here either. You live up
In
north of
Marietta.
here, Marietta, right? And you said Sarah Grace has never stayed with you. Is that right? Long term.
No, she's, you know, stayed with me.
Okay. She will not be staying with you. She'll be staying in Alabama if she's granted a bond.
Right.
Okay.
I don't worry, I have a 6-year-old that takes up a lot of my space. And
Correct.
toys.
Correct. If the judge were to say that the only way she can get a bond would be to come home with you, would you be able to house her?
I'd make it happen.
Okay.
So when your husband said probably, he was really waiting for you to say absolutely.
Now they're no longer together, Judge. They are.
Oh,
Excellent.
Excellent.
Yeah.
So you know I'm thinking.
And have you ever been to the house in Alabama where the defendant will be staying?
No.
She's going to. How long have you known this person, Carrie, that she'll be staying?
I've just known of her. I've met her here last time. I've not really known her.
Okay, so you just met her here earlier this month?
Well, I guess I've met her. So.
At one of the prior hearings?
It's something like that.
At the prior bond hearing back in August, probably? That's not okay. So you don't know her very well either? Okay.
But I will.
Understood. I'm sure you will. I have no other questions for you. Thank you so much.
anything else?
Briefly, Your Honor. Ms. Bruce, is it your intention to get Sarah out on bond so that you can, you know, help the production company get footage for their documentary and all of that thing stuff?
Absolutely not.
Okay.
I'm here for my granddaughter to be afraid. I think she's unjustly being tarnished.
Okay. Thank you.
Anything else you say?
Nothing else, Judge.
All right, thank you. You may step down. Yes, ma'am. We only have argument.
Yes, Judge, I do want to quickly make that packet, that same packet, it is a photocopy of the exact letters that I've given to the court as part of the record as defense's bond presented to.
All right, any objection?
None to the state, Judge.
All right, they'll be admitted.
Thank you, Your Honor.
We can get at the end.
Okay.
I'm ready for argument.
Okay. Your Honor, we believe that Ms. Patrick is in fact a good candidate for bond. I think that on the last bond hearing, the court heard from Ms. Bowling, who is the sister of James Brock, and her statements were of impact. She came up, she was emotional and teary-eyed, but the fact of the matter is that she is, as I told the court, only one side and one person of this victim family. I use the air quotes because, again, it seems as if to counsel that Ms. Bruce and Mr. Nolan are not being treated with the same gravity. Their words and their support for Sarah is not being treated with the same gravity as the other side of this, when in fact they are of closer relation as mother and father to the deceased than Ms. Bowling would be to her brother. And them being in support of Sarah, I think, should hold with this court more gravity in ways because of the close relation of them having birthed the deceased. Not to discount the emotion or feeling that Ms. Bowling may have for her brother, but that is a closer relation. The risk, the four factors that the court has to consider is that, is she a threat to the community, a threat to witnesses, risk to flee, risk to reoffend? The state wants to say that, oh, there's this influx of money and so she's gonna run. That, Your Honor, is at fault in the argument because none of that money belongs to Sarah. None of that money, she again is 17 years old. She's not an adult. She doesn't have a bank account. She doesn't have a driver's license, a passport, and they don't even think she knows how to drive. Not that Miss Bruce is aware of that she was even taught to drive. They didn't have a car for her to learn how to drive, was the testimony. And so her being a risk to flee, I think, is totally unfounded. In that she turned herself in voluntarily from Alabama. I think the state is going to argue to the court that she won't even be in Georgia. The court heard from Ms. Jensen on last bond hearing, so I didn't bring her back up, that she does stay right across the state line, and her house is where she came from voluntarily to turn herself in and be at the mercy of the sheriff's office and this court. And so I don't think that going back to Alabama would be a problem at all. It is a part of Ms. Jensen's letter that is a part of what has been turned over to the court, that she would be welcome there. We as a group, I've spoken with the family and with Ms. Patrick about where would be the best option for her to stay. I will say to the court that I have a list of some odd 15 people where she could reasonably stay. We have, as a group, considered all of those places and what would be the best course of action for making sure she gets to court, having a stable environment, being in a place where she could be away from the media frenzy that I think will surround her here in the immediate area. And so we just made that decision that Ms. Jensen's home there in Alabama, where she's already comfortable and would have the ability to stay off of social media, be somewhere where she wouldn't have the need for a phone and that type of thing, which I would ask the court to make that a part of the conditions of her bond, that she not have access to social media and a cell phone of her own. And that home just landed as the place that I think had all of those things encompassing, and a place where she would be comfortable. But that's not the only place that she could go. Your Honor could order that she stay here in the Carrollton area or in the surrounding area, and she has those places available as well. Several people have said that they would make sure that she has a place to stay and that she is housed. So her going to Alabama, I don't think should have that much weight from the court as a cause for concern. As it relates to a threat to the community, the people who are victims have said she is not a threat to them and a threat to witnesses. She is not a threat to them. She is not a threat to Jaylee. Never has been and never will be. And so the people who are closest to her, who talk to her on multiple occasions throughout her life, not just somebody who started talking to her after the incident happened, but they have said she is not a threat to the community, she is not a threat to witnesses. She is not at all a risk to reoffend. When we look at the risk to reoffend, I think that generally the court looks at a person's criminal history because we know past behavior is indicative of future behavior. She's never been arrested. That was presented at the last bond hearing. She still has no criminal history, hadn't had any incidents in the jail or anything of that sort. As a matter of fact, I think she is thought of and spoken very highly of by many of the guards there at the jail. Your Honor, we have presented to you 21 character letters. 21 people who are willing to vouch for that young lady sitting in that chair. 21 people, not just one person who is filled with emotion and feels like, that they have an emotional reaction to what has happened. 21 people. In addition to those 21 letters, that is a part now of the record that Your Honor has written. My right side, the court's left side, entire courtroom is here to support Ms. Patrick. People who are going to run generally don't have that type of support. People who are going to abscond from justice generally don't have that type of support. People who intend to not come back and not do the things that they're supposed to do not have this type of support, Your Honor. I think that is something that the court should look at in a major way as to the risk to flee. Is that when you have connections and ties, not only to the immediate community, but just to a community in the aggregate, that is what keeps people accountable. And essentially, bond is for there not to be any new crimes, which she doesn't have any indication that there will be any new crimes because she didn't have any criminal history. And we maintain her innocence, that she has not done this that she is accused of, but also that she just has the vast support of the community around her, and that they have said they will hold her accountable. That is a part of the letters as well as the testimony today. Again, as it relates to the money, Your Honor, if there is this vast influx of money, Your Honor, I'm sure, would not grant a recognizance bond. There would be a monetary amount to it. So any money that there is, that I think that the family has come into the way that the state wants to portray it, would be going to that bond, I can assure you. And in addition to that, she is indigent. And if there is any other monies, would be going to the hiring of an attorney, I would assume, if they could afford that based on this sudden influx of money, which the testimony has been, is that no money has been given to Mr. Nolan or Ms. Bruce, and that everything is post production. As it pertains to the veracity of their statements, Ms. Bruce was clear that they're not trying to get her out to, have her do interviews or anything like that. As a matter of fact, Your Honor could order that she not have any of those contacts or any of those interviews until after the trial. There is case law. I was not able to look it up because I was trying to pay attention and question, but I am certain that there is case law that, as a matter of fact, the defendant cannot profit off of books or publishing rights and those types of things as it relates to their case. And so I'm not sure if Your Honor is aware of that, and I can find the site as I continue to look and present that to the court if need be. But Your Honor, she has a place to stay. If Your Honor would require that she stay in Georgia or stay around the area, she has those places as well. We could provide addresses to the court. And so we're asking that Your Honor would grant a bond in this case. She is in solitary confinement as a 17-year-old. The courts have acknowledged that solitary confinement on juveniles is, even though she is being charged as an adult, she was at the time of the incident and is now still a juvenile. that it has vast implications on the mental health of persons, not just juveniles, but persons in general that are in solitary confinement. So I'd like the court to consider that as well. We filed this bond motion, Your Honor, because of the pushing back of the date, which was no fault of Ms. Patrick's, and no fault to the court. I think that it was what had to happen based on the circumstances. But the additional 8 months or so where we're going to be waiting, I think, is a factor that I think the court should consider in weighing whether or not the court grants bond today. But we would ask that Your Honor would grant a monetary bond with conditions. I am specifically asking that Your Honor would grant the condition that she not be allowed the use of a personal cell phone, that she not be allowed the use of social media. Your Honor has tools in his toolbox to say to keep her confined to a particular address. She can be on ankle monitoring, house arrest, with not the ability to go out and socialize or do any of those things. We now have the technology of GPS monitoring, so it's not just are you at home. They can tell exactly where you are. So if there is any question about whether she'll be out, being a threat to witnesses or the community at all, she could be closely monitored and will be closely monitored by her family. So Your Honor, we're asking that you would grant a bond in this case with the conditions that she not have any contact, of course, with witnesses, that she not have any contact even with, the Mr. Brock's family, if that is a concern, and also that she be on house arrest, ankle monitoring, GPS monitoring, so that the court will be aware of where she is, and I have no doubts that she will show up for her court dates. She is eager to assert her innocence. And so, Your Honor, that is the ask of the defense at this time.
Ms. Mitchell, if you'd like to come grab a seat, you can. Also, did observe you helped that young man in the back of the courtroom. Did you get him where you need to be?
Yes, Your Honor, I did.
All right, so.
Judge, I'm just waiting to grab an indictment and sign some out perfectly.
Okay. Madam Clerk, can you handle what she needs? You can go ahead and be productive. But I did look over that. I appreciate you helping him out. You could tell he was stressing. He didn't know where to be. Thank you. All right, Mr. Parrish, you ready?
I am, Judge.
All right.
Judge, the state does oppose bond in this case. You've done enough bonds with me to know I follow a particular protocol when I go through my bonds. I always start with the case history. We're talking about an incident date of February 20th of 2025. That is less than 12 months ago. An arrest date on this case was July 8th of 2025. This case went before the grand jury August 19th of 2025. We had a bond hearing on August 19th of 2025 as well, which I'm going to talk about in a minute. The trial court date on this case is set for August 3rd of this year, which is less than 1 calendar year from indictment. That is incredibly fast. Opposing counsel did mention the additional time based on the continuance that for all intents and purposes, had to be granted. That is not a consideration for the court. The court's structure in regards to this is pretty straightforward. There is no material change in the circumstances of the defendant. That's where we are. I'm going to read from that bond order on August 19th of 2025. After hearing evidence presented regarding the defendant's motion for bond, this court finds the defendant is a risk to flee the jurisdiction, not appear for future court appearances. The defendant is a risk to influence witnesses. The defendant is a threat to the community and family members as testified to at defendant's hearing regarding bond. Through all of the testimony and argument we have heard today, there has been nothing to dispute that fact. If anything, I think it could be argued that the flight risk is actually more significant now than it was before. The family in this case does oppose bond, Judge, and one other thing that I do want to address that was at the beginning of opposing counsel's argument. Our relationship with both sides is as much as we can make it. Miss Bruce, Mr. Nolan, and and DJ, the biological father of the defendant, they have been invited to our office constantly. Anytime we have spoken to the Brock side, we have reached out to the other side as well. They choose not to come. I sat down on that August 19th, 2025. We sat up in our brand new grand jury room up on the 5th floor, and I sat and answered their questions for at least a couple hours. I think it was about 2 hours that we were up there. They have been asked to come in every single time. I am inviting them to come into our office to talk to me today, tomorrow, any day, anytime. I cannot make this more clear. Anytime they want to come in and talk about the case, I am available to them. If they want to, we can set up a conference call on a weekend. If they need me to drive up to Marietta or up to Rome, I will drive up to Marietta or I will drive up to Rome. I drove up to Marietta a couple weeks ago with my investigator. Ms. Bruce was actually not there. So we have tried our very best to have a good relationship with them. They have turned their back because they do not believe that we are prosecuting the right person for this case. That was something I told them from the very beginning. I'm going to be as open and inviting as I can be, but we are not going to agree on that fact. They choose not to come in, Judge. I have conversations on the phone with Mr. Nolan and with Ms. Bruce because they live far away and it was difficult for them to come in. Any person in that family who wants to come in and talk to us can do so. At that meeting on August 19th, I told them to bring as many people as they want to. Friends, family, whoever they like. I invited them to record the interaction if they would like to. I have no problem talking to them. The state is not scared of talking to the family on either side. We invite them. Going back to the Brock side of the family, Judge, I do have a statement from them. They opposed bond as well for the same reasons that they opposed bond in the first time. I would like to read this statement from them if I could. The seriousness of the charges before this court cannot be overstated. The accused is being held and charged with the malice murder of 2 people. These were intentional violent acts that were permanently destroying our family. Granting bond in a case of this magnitude would undermine the gravity of these crimes and the devastating harm that she has already inflicted. Then they move to addressing the Ayala factors. We remain deeply concerned about flight risk. The defendant is facing the possibility of life-altering consequences if convicted. Given the severity of the charges, the incentive to flee is substantial. The immediate family has the resources which would enable her to flee. Her family maintains that she is innocent, and given her manipulative behavior, it is possible for her to flee. Once released, there would be no meaningful way to ensure the defendant remains within the jurisdiction or appears for future court proceedings, since family and close friends have homes outside of the state of Georgia. We are also gravely concerned about witness intimidation. This case relies on witnesses who must be able to cooperate freely and safely with law enforcement and with the court. Releasing the defendant creates a real and reasonable fear that witnesses could be intimidated, influenced, or discouraged from coming forward. Even indirect contact or perceived threats would be irreparably damaging to the case. Finally, and most urgently, we fear for our own safety. The loss that our family has suffered has traumatized us and left us vulnerable. The thought of the person accused of killing them being released into the community causes us constant anxiety and fear. Bond would not only endanger witnesses, it would also place our family under continued emotional distress and fear for our physical safety. The accused is being charged with 2 malice murder counts. These are horrific and violent crimes in which she is being accused. The defendant's second bond request, this is the defendant's second bond request, and nothing has changed that would justify reconsideration. The risks remain the same, if not greater, as the case moves forward and the consequences become more real. Our family would not be able to sleep in peace knowing that she is not in protective custody. Judge, it's the state's position that on August 19th of 2025, she was a poor candidate for bond, and that as I stand here before you today, she remains a poor candidate for bond, and bond should be denied as such.
Who made the statement?
So that was crafted by Kim Bowling on behalf of the other family, the Brock family.
Who was that? Who made the statement?
Kim Bowling.
No, that's the sister.
It is.
At the past hearing, we also had a brother testify. Is that right?
We did, Judge. We had sons. We had sons in her and then a friend of the family as well, if I recall correctly. It's going back a little bit.
I believe it was her brother, stepbrother. Is that correct?
I think so, Judge.
Is that right?
That's correct, Your Honor.
And he was not in favor at that time as well, correct?
Correct, Judge. There's significant numbers on this side as well.
And they lived together for a period of time, correct? The brother? That was my recollection, that he was in the house for a period of time. Is that not correct?
Not in recent memory, Judge, not in recent history, that is my understanding.
Anything else to say?
Nothing else from the state, Judge.
Anything else, Ms. Williams?
No, Your Honor.
Look at these letters. I believe it was actually Miss Carrie Jensen's letter that I referenced before I got started. She said, "I truly understand the difficult position this bond places before you and deeply respect the weight of your decision." And I didn't realize I was actually referencing hers at the beginning, but that's who Miss Jensen's the one who wrote that. So in preparing for this hearing today, I was prepared to listen for and hear anything that showed that there was a material change. As of right now, I don't see that there has been a material change. The only real change that has happened, one, is the court date change, and then two, I don't believe I had the information in front of me that family members had signed contracts with different media companies at the prior year. So that's new material. When I look at this, when I asked the state and defense to come up and the witnesses were testifying and the defense objected to the line of questions that the state had, my concern was I wanted someone to ask or bring up the question of the veracity of these statements, because I know, and I hope the family hears this, I'm not doubting your love for your granddaughter or your daughter. As Mr. DJ here, that's not in question. Okay? And I think I said this last year, so whatever ruling I make today, do not think that it is me determining your love and care for your daughter, right, or your granddaughter. With that said, I do have to consider some of the things that have changed in these type contracts. If she were to be released, y'all could benefit from your Ms. Williams actually used the term media frenzy. The more that's brought about, potentially the higher, the more you as individuals would receive potentially. So while that's not an factor that I have to evaluate, that is some of the change that in consideration of where she's going, who she'd be with, and they play into the factors of what could happen. But again, that does not play into whether or not you care or love your granddaughter or your daughter. Right? Going to the court dates, I don't believe that really goes into the material change argument, but it is a change in dates. And I want to lay this out. Ms. Patrick, I tried to take some time with you last time going through the arraignment process and going through the grand jury. So I'm going to lay this out for you today, okay? A typical criminal trial that most people don't realize, for that to be fast, for a criminal trial, especially one like this, a murder trial or child molestation or rape trial, these heavy crimes, right? Most people in the judicial world would say that a year and a half is a really fast track for that case to be heard. And I'm sure your attorney's probably gone over this with you, so you're shaking your head yes, like you understand that to be the case, right? So right now, when your case first came up, the first court date that I gave you, I was trying to push because I know your age. Right? And I want everybody to understand by me giving those first dates, do not drag your feet. But in all candor, if you remember, if you go back to that hearing when I set that date, I kind of had a little caveat saying, I understand this may be pushing. Right? And what happened was, as we came up, defense, you announced ready, but in actuality, you didn't even have your full report. And to do that, you would have needed that report. If we had started that day, you were thinking you might have the report by Friday, but you weren't sure. But I think you did what you had to do in the moment. Say you were ready, but you were announced ready without the full report that you truly need. State needs that report. They need that full report to do their job and have their expert. So, as both of you stated that day, and I believe the state even addressed here today, the continuance had to be given. The continuance had to be granted for fairness to take place, right? Fairness for you and your attorney to actually get the full report, and fairness for the state to be able to prepare for this case. Now, in doing that, I had a couple of different dates available. The state and defense both came to me and said, Judge, we know that you don't want to move this case again. We want to put it on your August date. That was the date that was agreed on by the defense and the state. If I look at the dates, right, now we just acknowledged, and you were shaking your head yes, as if you understood, that a year and a half is really fast for these type cases. That's typically as quick as one will get, right? If I look at my dates now for your August date, you hit right at almost exactly a year and a half. So even with that August date, your case is still moving at an incredibly fast pace. You realize that? Now, with that being said, state and defense also know I do not want to continue this case again. Right? And we're going to do everything that I can. I'm going to do everything that I can to prevent this case from being moved. Right? It's my understanding there may be some changes that take place. If those changes do take place, I do anticipate signing the board especially set this. If there are conflicts, I commit to both state and defense. I don't mind calling other judges that may have conflicts and ask them if they don't mind if we jump ahead in line so that I can have attorneys report to me so that we can make this happen. And I hope that we can do that. But when I look at this again, I think the state's correct. I have to evaluate it for material change. I don't see much of a material change. The risks that were there at your first bond hearing still exist. I do have to say I can see both sides, but I do see from the state saying that things may be even intensified with these contracts because that brings a whole level again of motivation. If you're what's going to motivate you or that side to do things, because the more that's there, the more they have, the more potentially they get. That's a risk too. So based on that, and based on evidence that was given to me at the prior hearing, I believe any time that I make a ruling that takes into consideration statements that were made at prior rulings, I have to place that on the record. So I am placing on the record that part of this ruling is based upon the testimony that was given to me at the prior bond hearing. Okay, the statements that I heard then. And I'm not giving more weight to one side or the other. That's just not the case. What I am doing is properly weighing this to the best of my ability against the law, right? And that's what I have to do with these factors, right? Based on doing that, I am going to stand with the original order that I gave. Bond will continue to be denied. I do not find a significant material change in circumstances or facts that would allow or require me to make a change in that prior ruling. So the prior ruling will still stand. Right, the case is set for our August date. Attorneys, we will continue our meetings as we've done prior to this. I anticipate us still having our monthly conference calls to make sure that we can stay on pace, stay on track. If there's a change, please let me know if there's a change. And whenever that change is made, I will continue to bring that person in to continue with these monthly conference calls so we can keep this case on track. All right. I do want to say again, Ms. Williams, you and your staff and the state have done a fantastic job keeping me informed of this case and making it a priority. I greatly appreciate that. Y'all have both done a great job thus far. And I anticipate y'all doing the same moving forward. That'll be the rule of the court.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.